In this video, we're going to address what happens if one or more of your heirs dies before you. So it's common for people to pass away, and perhaps they've written wills or trusts, during their lifetime, and life is kind of messy. So sometimes children pass away before their parents. Sometimes people leave things to siblings, or they leave things to people who are in the same generation or age group as themselves. And so there's a fairly decent likelihood that if you leave something to a sibling or someone in that same age group as yours, pretty good chance they're going to pass away before you. And so in this video, we're going to go through, what happens in those circumstances, and some fairly complicated rules can apply. And I got to preface this by saying many of the videos that I make, some of the ones maybe you watch them already or will watch some of the others, I've done hundreds of them, they're all estate planning related, and many of them apply to people wherever they live in any state in our United States, quite frankly in any country. It's just some common sense estate planning tips. While other videos like this one, they're really state specific. Because I live in Louisiana, I'm a lawyer in Louisiana, I help our Louisiana clients get and keep their legal affairs in order. And there are certain areas where state law can and does differ. So if you live in a state outside of Louisiana, this is going to give you some of the basic rules that we have in Louisiana, but you still need to perhaps consult with someone in your state to see if the rules are the same or different. But I'll be the first to admit some of our Louisiana laws in the estate planning area are a little unique. So don't rely on this if you live outside of Louisiana. Okay, let's jump right in. But I'm really just going to scratch the surface anyway. And wherever you live, this will give you an idea of what kind of stuff perhaps needs to be looked at under circumstances like this. All right, so I'm going to talk for a moment about when someone dies without a will and one of their potential heirs that would have inherited predeceases them, and then I'll get into some of the will stuff. So let me knock this no will stuff out of the way, and let me just scratch the surface. So normally, let's take an example where maybe a father dies and maybe he had been divorced, or maybe his wife passed away before him. And he dies leaving 3 children. He has no will. Never did a will. Never did anything. Never did put any estate legal affairs in order. Shame on him, but I shouldn't say shame on him because he's dead. But all right, I gotta get back on track. So he dies, and let's say he has 3 children, no will. But let's say one of his children died before him. Died 5 years before him. But that child had children. So if the parent, the father who died without a will, his estate goes to his 3 children, and if one of the children had predeceased the father, then the predeceased child's share is going to go to the predeceased child's children. They are going to represent their parent. And so things will go, 1/3 to one child, 1/3 to one child, and 1/3 to be divided among the children of the predeceased child. All right, and then really something, I guess similar rules apply if a person dies and they have no children, but let's just say they have no children, they have no surviving parents, and they just have siblings. And they have no will. Again, all this part is prefaced on they have no will. So realize we're getting to the will part in a minute. So person dies, no descendants, no surviving parents, but they got some siblings. Let's say they had 4 siblings, but 2 of their siblings had died, and those siblings had children. So the children of the predeceased siblings would represent their parent or the sibling of the person who died. All right, so that's just the very basics on when somebody doesn't have a will. When this often comes up is when someone writes a will and maybe their will is fairly old, still a valid will, but maybe they wrote it or had it written for them, 10 years ago, 20 years ago, 40 years ago. and people who were named in the will have died. That's common. What happens to those bequests? So now we get into some of our Louisiana lapsed legacy provisions, and we have to talk about what's called testamentary accretion. Big words, legal words, gobbledygook, lapsed legacy, testamentary accretion, but it is what it is. All right, so the first thing I'm going to say about it is if someone writes a will and they leave different stuff to different people, as we'll get into in a minute, and the will specifically provides what would happen to the portion that a predeceased person would have received, then the will controls. Let me give an example. Let's say let's say a person writes a will and says, I leave $100,000 to Larry. But if Larry predeceases me, I leave that $100,000 to my church, and they name the church. Then if Larry dies before, what we call the testator, is the person who wrote the will is called the testator. If Larry dies before the testator, then when the testator dies, that $100,000 is going to go to the church because the will addressed what happens if Larry dies before the testator. So if the will addresses it, the will controls. But oftentimes the will doesn't address it, then we have to go back to the rules. And the rules can be a little bit confusing. So let's jump right into it. And what happens depends on the relationship of the person who predeceased the testator and the testator. So let me give an example. We have a specific rule here in Louisiana that says if a legatee, that's a person named in a will, is a child or sibling or descendant of a child or sibling, then to the extent this legacy lapses, the person predeceases the testator, accretion takes place in favor of his descendants by roots who were in existence at the time of his death. What does all that mean? So that means if the testator writes a will and says, I leave $250,000 to my sister Sally, and just leaves it at that. And then Sally dies before the testator, and then the testator dies, then that $250,000 is going to go to Sally's children because of that rule that says if the legatee, Sally, is a child or sibling, Sally's a sister, Sally's a sibling, then the legacy lapsed and the accretion takes place in favor of Sally's descendants by roots who were in existence at the time of the testator's death. So if the testator would have wanted that $250,000 to go back to other siblings, back in the pot, as they sometimes call it, then there should have been a provision that if Sally predeceases me, that $250,000 goes wherever the testator would have wanted it to go. Okay, so that's the rule when the legatee is a child or sibling of the testator. Then there's a different rule and I'm going to call it on particular or general legacies, but same kind of deal, but the legatee is not the child or sibling of the testator. So let's say a person wrote a will and said, I leave $250,000 to my friend Fred. And they sock their will away, and then a few years later, Fred dies, and then a couple of years later, the testator dies. Who gets that $250,000 that would have gone to Fred if Fred was alive? Well, Fred is a friend. Fred is not the child or sibling of the testator. So under that set of circumstances, that bequest goes to who would have received it if the legacy had not been made. So then we go back to the testator's will, which says, I leave $250,000 to my friend Fred, and doesn't say what happens if Fred predeceases. And then later on in the will, it says I leave the remainder of my estate to Esther and Ellen. Well, Esther and Ellen then are going to get that $250,000 that Fred would have received if Fred had been alive when the testator died, because Fred, again, is not the child or sibling of the testator. So now you're starting to see where a distinction is made on these lapsed legacies regarding was that legacy or bequest made to a child or sibling of the testator or a descendant of one of them, one set of rules apply, or is that bequest made to someone who's not a child or sibling of the testator or a descendant from them, and then another set of rules apply. So keep in mind, depending on what state you're in, you might want to consult with somebody if you have that set of circumstances. Not every will needs to be updated when a person named in the will predeceases. You need to understand what these rules are to determine what's going to happen to that bequest now, and if you don't like the results of what would happen, then yeah, you do need to update or amend some things. So make sure you do, real important, hit the subscribe button, notification bell. You don't miss anything. 10 a.m. every morning Central Time. New estate planning educational videos. Love to see you smash the thumbs up button. Even more comments below that are kind of, my favorite comments are, and let me talk about comments for a minute. They're proofread. They're grammatically correct. Maybe they're not quite so in all caps. I don't get that much, but whenever I see an all cap comment, I feel like people are shouting at me. And then really what I can't answer is that specific legal question of, Paul, my stepdad died, or my mom died and my stepdad went into the house, took all the money, can I sue him? Or, all those that sometimes people give me the family history and say, what are my rights? And I just can't answer those questions. I can't answer specific legal questions. But, however, if you want to give me a suggested topic for a video that I could generally discuss and not appear to be giving you some kind of specific legal advice without me understanding all of the circumstances, I really find those suggested topics valuable, and many of them I add to my list of videos to make. Okay, y'all have a great day. See you tomorrow.